Your neighbor just became a criminal overnight, and they probably don't even know it yet. On January 1st, 2026, millions of California gun owners woke up to a new reality where the way they've been storing their firearms for decades could now land them in jail. But here's where it gets really interesting. The law enforcement officers who might arrest you for this are probably breaking the same law in their own homes right now. Let me tell you what's really happening here, because this isn't just about locking up guns. This is about a fundamental shift in how the state views your right to self-defense in your own home. And the penalties, they're designed to escalate so quickly that by your third offense, you could be facing 6 months behind bars. The new storage requirements that kicked in this year through Assembly Bill 53 have created a legal minefield that most gun owners haven't even realized they're walking through. And I'm going to show you exactly why this law is more dangerous than it appears on the surface. First, let's talk about what this law actually requires, because the devil is truly in the details. Under the amended Penal Code sections 25100 and 25145, every single firearm in your home that isn't under your immediate control must now be secured with either a certified firearm safety device or stored in a secure gun safe. Sounds reasonable enough, right? Well, wait until you hear what qualifies as immediate control. The law defines 3 different degrees of criminal storage, and this is where things get really concerning. First-degree criminal storage is now a felony. Let that sink in for a moment. If someone stores their firearm in a way that a child or prohibited person gains access and causes death or great bodily injury, the gun owner faces felony charges. Not for pulling the trigger, not for handing someone a gun, but for how they stored it in their own home. Second-degree criminal storage kicks in when someone gets hurt but doesn't die. That's a misdemeanor with up to a year in county jail. But here's the kicker. Third-degree criminal storage doesn't even require anyone to get hurt. If the state decides you reasonably should know a child might gain access to your firearm, you're looking at 180 days in jail. No injury required, no actual access required, just the possibility. Now you might be thinking, well, I don't have kids, so this doesn't apply to me. And that's exactly where this law becomes a trap. The definition of residence in this law is so broad, it's almost laughable. We're not just talking about your house. This includes hotels, motels, timeshares, RVs, and basically any structure where humans might sleep. Got a friend visiting with their kid? Your storage requirements just changed. Staying at an Airbnb? Better bring a gun safe. But wait, it gets worse. Remember how I mentioned that exemption for people who had no reasonable expectation that a child would be present? That's gone. Completely eliminated as of January 1st. So even if you live alone, never have visitors, and haven't seen a child in years, you're still required to lock up every firearm that's not physically on your person or within arm's reach. Let me paint you a picture of how absurd this can get. You're home alone watching TV with your concealed carry pistol on the coffee table next to you. You get up to use the bathroom. Is that gun still under your immediate control? According to the strict letter of this law, probably not. You've just committed an infraction punishable by a $250 fine. Do it twice, that's $500. 3 times, now you're facing misdemeanor charges and potential jail time. The state wants you to use their approved safety devices, and here's where it gets really interesting. The Department of Justice maintains a roster of approved devices, but when you actually look at this list, it becomes clear how poorly thought out this system is. Many common firearms aren't even on their list. So what are you supposed to do if you own a gun that doesn't have an approved safety device? The law doesn't say. Those cable locks that come with new guns, the ones everyone immediately throws in a drawer and forgets about, those are now your ticket to staying out of jail. But here's the problem. Those locks are notoriously easy to defeat. Any teenager with YouTube and 5 minutes can figure out how to bypass them. So we have a law that prioritizes checking boxes over actual safety.
First and foremost, basic gun safety does not have to be a threat to the Second Amendment.
All right, we've got this breaking news just coming into our newsroom right now.
Now, SB 53 will take effect starting January 1st, requiring firearms to be securely stored when not in use.
There are some states and commonwealths we're talking about where this will be a felony.
The weapons unto themselves, they're not the problem. The problem is, what are you doing with the weapons?
It is unconstitutional.
You need to be on the right side of the law because the legal system is complex.
The requirements for gun safes are even more specific. The DOJ has published standards for the thickness of steel walls and locking mechanisms. But here's what they don't tell you. Many of the gun safes sold in California, sporting goods stores don't actually meet these standards. You could buy what you think is a compliant safe, store your guns in it, and still be breaking the law. Now, some of you might be wondering how anyone would ever get caught violating these storage laws. After all, the police can't just walk into your home and check your gun storage. That pesky Fourth Amendment still exists, at least for now. But people find ways to get caught that would surprise you. Maybe you have a plumber over to fix a leak and they see your home defense shotgun leaning in the corner of your bedroom. Maybe you post a photo on social media that inadvertently shows a firearm in the background. Maybe you go through a messy divorce and your ex decides to mention your storage habits to the authorities. Or maybe you actually use a firearm in self-defense and suddenly every aspect of how you stored that gun becomes evidence.
Open carry has historically been regulated. The U.S. Supreme Court has said those types of regulations would be improper.
Typically in a lock safe like this one or another safety device with the goal of preventing unauthorized access.
Our citizens want gun safety, want firearm safety, want community safety.
That seems like guilty until proven innocent. That's not within the lawful jurisdiction of a government.
If you're going to restrict a constitutional right, it has to be consistent with the nation's historical traditions of firearm regulation.
The public is demanding of its public officials that we take action.
Here's a scenario that should concern everyone. You hear someone breaking into your home at 3 a.m. Your gun is locked in a safe in your bedroom closet as the law requires. By the time you wake up, process what's happening, get to the safe, remember the combination under stress, open it, and retrieve your firearm. The intruder is already in your bedroom. The very law designed to keep people safe has just made you significantly less safe in your own home. The timing aspect of this law is particularly cruel. Quick access safes with biometric locks seem like the obvious solution, but what happens when the battery dies? What happens when the fingerprint reader doesn't recognize your print because your hands are sweaty from stress? What happens when the electronic lock fails, as electronic devices sometimes do? The law doesn't care about these real-world complications. And let's talk about the financial burden this places on gun owners. A quality gun safe that meets the DOJ standards isn't cheap. We're talking hundreds or potentially thousands of dollars depending on how many firearms you own. For many people, this effectively prices them out of their constitutional right to keep and bear arms. Can't afford a compliant safe? Then you can't legally own a gun in California anymore.
This shift could influence all circuit courts.
Local gun stores say understanding how to properly store firearms will be key for gun owners moving forward.
Members of the Senate are focusing on gun rights in the wake of the Supreme Court's Bruin decision.
There's a myriad of things that can tie you up legally, financially, put you in jail, or maybe get you in very serious trouble with the police.
This is something that actually comes from common law England. The king is sovereign, and the government has to waive that sovereign immunity.
It's not the gun owner, it's not the pistol permit holders, it's the criminals that are causing the violence and the gun problem.
The enforcement mechanism is particularly insidious. First offense, just a fine. Many people might pay it and move on. Second offense, higher fine but still manageable. But that third offense transforms into a misdemeanor. And once you have a misdemeanor conviction related to firearms, guess what? You might lose your right to own guns entirely. It's a gradual escalation designed to slowly tighten the noose. What's particularly frustrating is that this law doesn't actually address the stated problem. California already had laws against allowing children access to firearms. We already had laws requiring new gun purchases to include safety devices. This new law simply makes criminals out of ordinary people who pose no threat to anyone. Consider the elderly person living alone who keeps a revolver in their nightstand for protection. Under this new law, they're a criminal unless that revolver is locked up. Consider the rural property owner who keeps a rifle by the door for predator control. Criminal. The single mother who keeps a pistol accessible for protection while her children are at their father's house for the weekend? Still a criminal because the law eliminated the exemption for times when children aren't expected to be present. The real tragedy here is that responsible gun owners who would never allow unauthorized access to their firearms are being punished for the actions of a tiny minority. It's collective punishment disguised as public safety. And the people who are actually negligent with their firearms, they're probably not going to follow this law anyway.
First of all, it's important that you know the gun and concealed carry laws in your home state and anywhere you plan to carry.
Even if you are innocent, your words can still be twisted and taken out of context.
The fact that you have a concealed carry permit does not mean you get to go anywhere you want with your firearm.
A lot of what we hear this morning is trying to figure out what is our nation's history and tradition.
It's your responsibility to stay on the right side of the law.
And I think it's pretty simple, is that we want to do our due diligence if we're looking to give people gun rights.
This law also creates a bizarre situation where the same firearm can be legally stored one moment and illegally stored the next with no action on the part of the owner. Walk into your bedroom with your carry pistol, legal. Set it on your dresser and walk to the kitchen, potentially illegal. The gun didn't move. You moved. But somehow a crime may have been committed. The practical implications extend beyond individual gun owners. Think about gun stores, training facilities, and shooting ranges. How do they comply with these storage requirements while still maintaining a functional business? The law is so broadly written that it creates uncertainty in countless situations that the legislators probably never even considered. What we're really seeing here is an attempt to make gun ownership so legally perilous and practically inconvenient that people simply give up. It's death by 1,000 cuts. Each individual requirement might seem reasonable in isolation, but taken together, they create a web of regulations so complex that perfect compliance becomes nearly impossible. So what can you do? First, understand that ignorance of this law is not a defense. You need to make decisions about how you're going to comply, whether that means investing in approved storage devices or reevaluating your home defense strategy. Second, stay informed about any updates or clarifications to these requirements, because in California, gun laws have a tendency to change quickly and without much notice. The supreme irony is that while law-abiding citizens are scrambling to comply with these storage requirements, criminals are still stealing guns, still using them in crimes, and still completely ignoring every gun law on the books. This law doesn't make anyone safer. It just makes more people into potential criminals. As we move forward into 2026, California gun owners find themselves in an increasingly difficult position. The right to keep and bear arms is being slowly regulated out of practical existence, one storage requirement at a time. And unless something changes, this is just the beginning. That's it for today, folks. See you in the next video.